This video is clips from a formal Zoom hearing in May of 2021, which I didn't participate in. And long story short, a lot of my best evidence was concealed in it and or was not discussed in the context of. So the purpose of this is to inform people who may be interested in the truth and nothing but the truth.
There are 3 audio recordings that the taxpayer submitted. We will not receive those into evidence. One of the recordings is of the County Board of Equalization. We have the record, the Board of Equalization hearing record available to us. We will review it. But the purpose of this hearing is to take a fresh look at the evidence and the arguments and make a decision. We're not here to criticize the County Board of Equalization or their procedures.
February 15th, got a Board of Equalization meeting today at 3:20.
Oh, did they send them to you? Oh, because I have it.
This is a basement entry.
The assessor's comps, they're not my comps. But
Tiles
is
missing
that what you're talking about? You haven't seen the assessor?
and molding. That's a repair.
I don't have any idea. I just had this
Caulk.
conversation with Matt. That's what we were talking about. He's been
Bathrooms was completed in probably 1992.
I make sure that I make a copy of the assessor's.
It's
comp.
mixed up moldings randomly.
You should have them.
This is a casing mixed with a baseboard.
She told me she was sending something to you, so you have the comps.
This is all baseboard.
Well, I'm gonna give you a piece of paper that has everything on it, but you're not gonna get that.
So this bathroom would need to be totally remodeled.
And here's what we're gonna do, I'm gonna.
Some places where the baseboard, that's baseboard, that's door casing. It's mixed.
Yeah, I do, but here's, I don't even know why.
This is a
So we need to, okay.
kind of
So
a mini bar.
you want a proposed value of 520.
It's got to be
And
removed,
assessor's
as
value
well as the
is
cabinets.
672. So that's the difference in value. And
Typical every window. The
what I
carpentry,
want is whatever you
the
want to
person
give
doing
me,
the carpentry didn't know
and
what they
then
were
we'll
doing.
talk about,
That's a very simple 22.5 degree
okay, 'cause this is
miter.
this is really hard.
There was a lot of fluorescent lighting that'll have to be
Yeah,
taken out, re-sheetrocked, installed more updated light fixtures.
so let's see how far. Who said?
Kind of a
Well, they're not, they're all.
caulk repair.
Aren't they pretty much together, the neighborhood codes?
One room has been remodeled.
Okay, so the appellants.
That was done about a year ago.
This is very interesting. You've got,
Storage space.
I haven't seen this.
Previous
What we do is
appeal
when you're gone, after you leave.
showed the whole basement was 100%
Matt and I will go over all these files. And then
finished.
we'll make a recommendation to the Board of Equalization, and they will go over the files.
One bedroom's gonna have to be totally torn apart too. A lot of molding problems. Just cheap construction. Those are tubes that are meant to be used for pouring cement. This is a use of casing mixed with baseboard. The profiles don't match. You typically don't put a glass door on a bedroom for privacy concerns. Well, that's about it in a nutshell.
Maps, interactive maps, and looked at my next door neighbors and 20 houses up behind me. They were all barely under 200,000.
This is a difficult way to proceed. without the petitioner, because we don't know for certain what he wanted to emphasize in his exhibits and what he wanted to actually present to the commission, but we'll do our best to go forward. But I do think it's important for the commission to understand the nature of this home. And as you'll see on this slide here, it is a very large home, over 5,000 square feet. And it is over a half an acre. And so that is large as well.
Now, they didn't do that.
And then it is in a desirable neighborhood. Across the street is a park for horse riding and jogging and other things, and it's close to the canyons. It was built in 1992 as a semi-custom room, but it's been substantially renovated, at least upstairs. So a new roof has gone on. Living room, family room, kitchen, master bathroom, all have been remodeled. Now, the county has not been permitted to inspect the remodel, so we don't know the grade per se. We have conservatively, I think, placed it as average for upstairs, but it is new, and it is new for this lien date for the most part. And of course, a new roof was installed in 2018. So those do increase the value of the home from an effective age, and that in part translates to the assessed value. This is a picture of the front of the home, and the nature of the lot does, as I understand, allow for a valuable view from the back where you see the porch and so forth. It does have, as you'll see, the large garage, but it also has a high garage for boats and other items, which does help. Here is the location. You'll see the park across the street, and I think it's important for the commission to note that the homes that surround it are very large homes as well, for the most part. This is a desirable location. You don't put this size of home and this valuable of a home in an area that typically wouldn't support it. So it is in a good neighborhood, and the reason why I emphasize that is because the comps or the comparables that the petitioners continue to present, both in this hearing and the hearing below, are not in the same neighborhood, nor are they the same size. And so you get a mismatch from the get-go. Now, here are the values, and the assessment, as the commission indicated, was sustained by the BOE, and it was $672,900. You'll note in 2018, for reference, it was $542,200. That was the value the commission sustained in the 2018 decision. The taxpayer, the $568,000. I'm not certain what the taxpayer is actually asking for. He did cross out and put in a number close to this, and submitted this as an exhibit to the commission, which was his petition or appeal, where he stated the value, and I think the commission just needs to go on what he's put on the exhibits and not what I've represented here, because that seems to be a moving target. So I apologize in that regard. So I do want to emphasize why there was an increase in value. It had nothing to do with anything other than in 2018, because of the remodel upstairs, the county had assessed it as only 75% complete. So in other words, they assess it as if it was under construction. In 2018, our understanding, and it seems to be consistent with what the petitioners represented, those improvements were all complete, and therefore it was changed to a 100% complete home. like any other home that would be assessed. That 25%, obviously on just a raw adjustment, would increase the 2018 assessment well above what we've assessed it at in 2019, but of course that's focused on the building, not the land. So it doesn't translate directly to 25%. And of course there is the market increase in value that did occur between 2018 and 2019 for all homes in this area. So those two reasons would be why the value is substantially higher than it was in 2018. And I can't emphasize this enough, that assessing the property at 25 or 75% in 2018 does impact value significantly. And when the home is complete and the remodel was done, it goes to 100%. Now, the taxpayer, for whatever reason, seems to confuse this 100% with meaning that the county has determined that the property was 100% remodeled in 2018. That is not the case. We fully recognize that only the upstairs, which is the most important part, was fully remodeled in 2018 for the most part. The 100% complete is simply that construction is done. And yes, the basement is older, but construction has been done and was done some years prior to that. So the taxpayer, the petitioner, seems to confuse the 100% complete with somehow a misunderstanding that we mean by that we assume that the whole house was remodeled 100%. Is there any question on that, Your Honor? Does that explanation make sense? If not, I'll move to the next slide. Petitioners do carry the burden of proof to show material error. Actually, I think that should be substantial error, and a sound evidentiary basis in the BOE's decision, which sustained the assessment. So here are the arguments the petitioner made before in 2018, and they seem to be the same. Our response to the basement is nothing's changed. We still have not had a full inspection. We even went so far as the motion to compel indicated to seek that through Utah Rules of Civil Procedure 34. And the taxpayer, even in the documents he submitted here today, seems to think that he selects what we see. And so he thinks it's okay for us to take his word for what the remodel was upstairs, but then downstairs, where he seems to have concerns as to workmanship and others, he shows the videos. Oh, okay. I think we've addressed this before, Your Honor. I'm sorry. Let's move to Exhibit 5. I'm sorry, Your Honor. I should have taken better notes, but
The state's quality grade chart was submitted by John Lennell in the 2018 hearing. I resubmitted it for the 2019 hearing because of the video that I submitted and the photographs that showed that poor workmanship is poor. There was no reduction for it. When the chart showed up in the Zoom hearing, Bodily basically, we've already discussed that. Let's move on. If you read paragraph 24, he says there are issues, but poor condition is, he calls it structural. That's what they said in the 2019 as well. Notice that on paragraph 25 that it was undervalued. So when they learned it was undervalued, that was the reason for the increase, not so much remodeling. They do mention that most of the main floor had been remodeled. What was submitted as evidence was the only remodel for the tax year, which was censored, concealed as evidence to prove what the facts of matter really were.
18's fine.
This was an exchange of emails from Ephraim Olson, my attorney, and Tim Bodily. I didn't see these until I asked for them the day after Ephraim resigned. I knew what had been info given to him, but then Bodily wanted to see get a home inspection under Rule 34. I did respond to his email, and I told him that, and Ephraim, that it was not applicable to see a house in March of 2021 for the lien date of January 1st, 2019. But anyway, that's when, after he resigned, that's when Bodily did the Rule 34 on me. But and Bodily saw this 51 days before the Zoom hearing. So he was well informed of what the change was, a qualifying change. And there is one photograph down here on the bottom right that shows the studs. In the other parts of the Zoom hearing, Bodily said that the house was stripped to the studs, under construction. Yeah, one bedroom was bedroom. I submitted this. It did not show up as evidence. Resubmitted for reconsideration. It was denied as no new evidence submitted. This change, they think, qualified for an increase of $130,700 over the previous tax year that already had said that most of the main floor was finished. He got his ways. And another email sent to Bodily and Watcott was a counteroffer to Watcott's offer. He offered something like $630,000. We counteroffered at $568,000 based on an appraisal, all kinds of facts. He thanked us for it, but however, he still wanted to see an inspection of the house. So when I submitted it as evidence, when Bodily noticed I had, he counter-offered. He gave the exact same offer the assessor did. Plus, I had to accept the 2020 assessment to close all the cases. That was a bribe, so to speak, to include something that was not related to the hearing. When I filed notice on May 9th, 2022, that I was taking it to civil court, I used Rule 34, asked them to send me the alleged email, and also the fact that why they keep calling the house an estate court sale. To this day, almost 60 days later, they have not responded. Other evidence, this is just the tip of the iceberg. It was submitted. It was not shown or discussed. One property that's built by the same builder. Identical floor plan. That was not even shown or discussed. Nor was my rebuttal to the Board of Equalization hearing.
The percent complete. So that percent increase is reflecting the subject property being moved to 100% complete for the 2019 tax year.
But the 47.9% isn't the difference between 2018 and 2019. It's the difference between the sale price in 2016, right?
Yeah, So it's not. In other words, it's not unwarranted for the subject property to go up 47.9%. That the subject property was purchased and then remodeled, so it's expected that the value would increase in the years following.
And the sale was an estate sale in the first place.
That's correct.
The commission has already addressed that sale in its 2018 decision. Is that correct?
Yeah, that's right.
In our counteroffer submitted that was concealed, it also noted in there that it was not an estate court sale. And in 2020, when we had a mediation with Mr. Watcott, I accused him of perjurious testimony in the formal hearing. And I asked him to send me the evidence that supports the allegation. He said he would the next day. He never did. It's been almost another year since. So why they keep making that accusation is unknown. Even if it pretending it was an estate sale, the 2018 would have brought it up to the property valuation. They just keep manipulating everything to get their way. You try to prove their way, my way, they ignore it and conceal it.
I'm here now. And I've got to stick to my time frame now because I've got 4.
It's in the appraisal
coming
that he
in.
submitted. The appraisal was not
This is
included
lining
in an inspection either.
Shows you what I just showed you in the video.
Oh, that's the collage.
And then subsequently, the appraiser did communicate with the county
I mean, you
and
know,
asked that the
it's kinda
appraiser
like the consumer
not
buying a house.
the appraisal not be
Okay,
used
so here's.
and not
I
be
don't care what a
considered.
house looks like.
Here's it.
I mean, when we.
We'll testify
we
and
go
offer
out and
evidence
fix
that
it up.
our assumption is
Fixer-uppers
that was
sell
partly
for
done
less than
because
houses
the
don't.
appraiser learned that the upstairs was
I
in
like that
significantly
collage.
better condition than what was
But
represented to him
I've
and what he
seen-
assumed in his
I-
appraisal, and you'll see the adjustments there, and we'll discuss that when we get there.
It is.
My texting with the appraiser contradicts what Bodily just said. I asked him to do a video chat. He says it wouldn't
Okay,
help.
so send it
Then I
to-
offered to pay him for the
send it to the Board of
appraisal 3 times.
Equalization.
He never responded.
And I'm your hearing officer, and tell them that you want me to have it.
And the last thing I'll ask is that he does ask for
And then I have to
opportunity
kick
to
you out of here.
respond
I'm gonna give you this, I don't usually do this.
to our
Because
evidence.
I'd like to have
and
it, okay?
I don't know how the commission wants to handle that,
And then we can all
because
take a
this
look
could
at
go
it.
on forever through emails and responses. This was the time certain for the taxpayer to present his rebuttal evidence, and I think the commission should
Okay, this is
close
on
the
number
evidence
27.
portion of the hearing at this time, and that would be my motion.
Probably not.
And we'll grant that motion and close the record.
I can't address that.
We'll take the information received under advisement.
I don't know.
Commission will issue a written decision, and that decision will include appeal rights available to either party.
All right, thank you for your time, and I'm sorry it was complicated, but the Zoom did help, so I appreciate that, Your Honor.
All right. I have
Do
to
it,
kick
thank
you
you.
out.
With,
I'm sorry.
I will go ahead and
But,
stop the
no, I don't
recording
have that
now.
collage thing. I don't know why. It's not.
It took 4 months to get a
You
decision
weren't supposed to look
on
at
this
thing.
case. They sided with the assessor. So I filed for reconsideration. I submitted
Okay,
5
you wanna send it
emails,
to me?
3 very lengthy rebuttals, objections in PDFs. 4 months later,
Yeah.
denied.
I can't send it
No
to
new
you.
evidence was submitted. No mistakes of laws were made. This entire coup operation is perjurious in every way, shape, and form. I showed Sharon Lies, number 26, the video of the basement. She asked me to send it. I did. Next day,
The rules.
and the decision came back. It was submitted late and would not be considered. She basically
Oh, would
concealed
you now? Come
evidence
on.
in an informal hearing.
Well, we're gonna look at it and decide, okay? And this nice patient man's, I'm gonna make you leave. I finally get to talk to you. You need to give me
A couple weeks before the tax commission mailed me the
I
decision,
don't know how to-
I emailed the tax commission and told them that I noticed not all of my evidence was presented. Send me paper copies of everything. And I also accused Watcott and Bodily of committing perjury. Their response was, "We're confused. Call us." There was no point in calling them. I don't want to hear it.
And in the course of talking, he has something that's like, well, he calls it a collage, that he wants us to have a picture of. and he can't email it to me, where can he email it?
When the meeting with Sharon, she said that she had never seen the assessor's full disclosure yet. And she had not even seen everything that I had submitted. So the whole meeting was like very confusing why you submit everything and she is not there to show it and talk about it.
Appeals, oh, that's what I thought. Okay, that's what she. Or email it to Pam and she'll give it to her. Can you email, and since he's been emailing back and forth with Pam upstairs, can he just email it to her and she can give it to us?
You could, that's one, probably a little bit.
I was becoming ill with laryngitis a few days before the Zoom, so I asked for an extension, denied, because it wasn't submitted within 10 days. So I wrote out an email, what I would say tomorrow to use as my evidence. It was admitted as an exhibit, however, it was not even discussed in any way, shape, or form. I did mention that the only remodel was the master bedroom, the bathroom, and one other bedroom, and a bunch of other stuff. Some of it was mentioned in the formal decision, but not the best stuff that would promote my perspective. They did close the case. I was not even allowed to object afterwards. That was for Bottle's motion, as this could go on forever. Commissioner Cragun granted it without hesitation. It was disturbing, to say the least, to have your rights violated by a judge.
This way, are you calling me?
Mr. Watcott never called in advance to inspect the house. He left a card on the porch.
At C.
In my email to them, I told him this is the best time would have been to view the houses if he would have asked in advance.
Number 26.
But he didn't. But if you're on the porch, you'll see there are 6 windows. You can see just about the entire house from the porch, excepting the master bedroom and the bathrooms and the other 2 bedrooms. Under the law of tampering with evidence, it calls out as a thing or an item. My testimony in written form was a thing. Just like everybody else, everything else, it's a thing. This is the email submitted that added my additional evidence for the Zoom hearing, which included the master bedroom, the bathroom, photographs of it that did not show up in the hearing. So what do you do when your best evidence is concealed? All those photographs of the remodel are dated to prove that what happened. Most of it started in just right after January 1st, 2018 and was completed by March of 2018. So that was the only qualifying change for the tax year. Some of this email also submitted evidence for the 2020 hearing, which there has not even been a formal hearing for that yet. It has been set up for a status conference call. I got notice of that just a couple days ago. But they're all the parties already know that I already filed for a new trial de novo on the case. That way everybody can be on the same page. All the evidence can be reviewed by an impartial judge. I hope is impartial. When Bodily saw that I had submitted the counteroffer, he responded with this email 5 days before the Zoom hearing if I did not accept it, which included that I accept the 2020 assessment. That was a bribe, so to speak. He blocked it. Under the canon law 2, a judge shall perform the duties of judicial office impartially, completely, and diligently, fair and impartial. I can't believe that you have all these laws on the books that they can't quite comply with. So I put everybody on notice for a new trial de novo on May 9th, sent to all respondents. They're required to respond within the 60 days, and that date is tomorrow, July 8th. No one has responded yet. So that will be a new trial, whereas all the evidence will be submitted again for a fair and impartial hearing. Other evidence that was concealed was my annotated notes on Sharon Lai's decision, as well as the previous 2018 decision. If it hurts their case, conceal it. 3rd-degree felony in a formal Zoom hearing. Sharon Lai's number 26 decision doesn't match the audio file. That's why they concealed it. So all of these evidence I submitted, they weren't entered into as evidence either, including the 2018 Board of Equalization decision. Basically, the Board of Equalization is very, very biased. They tell you they're not. They don't work for the government. They're just here to hear the evidence. And by the face of the law, part of the discussion in a BOE is part of the record. The assessor also submitted the 2018 Board of Equalization record. I didn't see this until 14 days before the 2018 hearing. That was almost a year after it was created. So that left me 4 days to respond to 25 pages. So, needless to say, I lost the appeal. They won. They prevailed. Sustained an increase of $129,200. And I was okay with that, so to speak. But when 2019 popped up for $130,700, that was a red flag. Time to appeal again. This is in part the order of reconsideration of denial, stating that I had not submitted anything new, no evidence, no mistakes of laws made. I totally disagree. I resubmitted everything that was not entered into the hearing. And all the emails that I had exchanged with Bodily. And it just makes no sense that they concealed it from the get-go, and then ongoing, same thing, same song, second verse. So that they all have been put on notice for a trial de novo on May 9th. With 60 days to respond, no one has responded. Tomorrow, July 8th, is the day of 60 days, whereas I can file it in circuit court or district court. I haven't figured that one out yet. So if you're looking for an impartial property tax dispute, you're going to get it. No ifs, ands, or buts about it. I filed a bar complaint against Mr. Bodily on May 27th, and it was about a 24-page document. Didn't go into supporting evidence like this does, but nonetheless, if by the color of the law that they noted there, one sentence says that they will seek more evidence if they suspect misconduct. They're also required to send the response back to me. I still have not seen that. I have requested it twice. I still have not received it. they transferred it up to the ethics committee, whereas they said they will accept more evidence. So it appears as though they don't want to investigate a government attorney in any way, shape, or form.